There you go, Dean. Up on the screen.
Okay. I can't see it from here.
I know.
Oh,
I gotta put it, I need one too.
I know you sent us an email with everything on it. but-
Yeah, that's,
yeah. She sent the email that she sent yesterday about the dress. It's at the bottom of that one too.
can you see this? How big or?
Bigger.
Yeah, sure.
Oh, yeah. Right at the bottom is, you know.
You want me to find it for you?
Yeah.
Okay. I sent it to your personal email, that's why.
Oh, that's why.
And I didn't print because I didn't figure anybody would be checking their department.
You are correct.
Yep.
I checked mine.
Yeah.
Really? I know.
So we are recording, we are ready to call the order.
So it is about 10 minutes of 11 on Thursday, the 25th of September, and we're at the Rutland P&P office and calling the meeting of the staff meeting of the parole board to order. First order of business would be to review our agenda for today's meeting.
Agenda on your screen. Just realized I changed it yesterday.
Can't bring this up on my screen.
One on the cell- The one on the cell phone.
I left my cell phone in the car, so I can't bring it up. Has everybody had a chance to review the agenda?
Yes.
A motion for its approval would be in order then?
Second.
Motion's made and seconded to approve the agenda as written. All in favor signify by saying aye.
Okay.
Is unanimous. Do we have any minutes to review as well?
Yes, August minutes, I did not, they were on our website, I forgot to distribute, I'm just so used to them being on our website.
Yeah.
I apologize, if you didn't review them, we can hold off until next month.
Okay, let's do that. And first item up is Cassidy. Good morning.
Good morning. Glad to see you guys in Rutland.
Yeah, nice to be here.
The office was like really excited to see
Yeah.
you. That was kind of nice. It's been a long time since I think the parole board's been
Yes,
in an office in person as we used to be way back in the day, I suppose.
spent a lot of hours in this room.
Yeah. Yeah, right?
Oh, no.
So Mary Jane had, and I just wanted to follow up, had sent an email pertaining to some questions and a few topics. So I did send a response. I didn't know if you wanted to have that.
I didn't pass it along.
Oh, okay.
I just thought maybe we could just go
Yeah.
through topic, I was just pulling it up.
Perfect, I did too. So I just wanted to make sure I will get my responses, make sure I say the same thing. Don't change my mind.
So I think the first one on the list, I'm still pulling it up, but the first one on the list was around approved housing condition for transitional housing.
Mhm.
Because it's come up that DOC, the casework staff are not applying, or I think it came up from the PMP that transitional housing applications wouldn't be submitted unless our approved housing condition 16 was assigned.
Mhm.
So, and this is a little bit on DOC's communication out, as well as because we do, and people who have worked with us before, we've leaned into condition 7 that you have around programming. We've
Right.
often linked that into the transitional housing. And also you'll see in violations, if someone gets terminated from a Berry CJC because of the type of services they receive, that you'll see that violation is on the programming thing. Obviously, we would prefer you to apply if they want transitional housing with your additional condition number, what's 16 around the residents. We would prefer, but again, it's the parole board's discretion because we do actually use it under your current condition of condition 7. This goes into your original proposal of changing your conditions in general. One solution is utilize the condition 7 and condition 16 for that transitional housing. But you also have the discretion around the condition is it 18, where you can write in
Special condition.
your special condition as other, which we can adopt into
Mhm.
our writing that in as an
Yeah.
option for the parole board. We would prefer it. Probation has adopted it, and so has community furlough supervision, because we're looking at the amount of services people do receive in transitional housing, that if they bomb out 3 times, you know what I mean? Like
Yeah.
at that point, we need to be able to respond. We're finding an increase of, it's actually been crazy. We've had an increase of, I think we've pulled out this year 2 people having weapons in the home, so we need some of that,
Yeah.
that residence to reside, especially when we're looking at higher increase of high need, high risk individuals. So that kind of answers that one. So, but it still remains the board's.
One of the things, Cassie, that's come up recently in a couple of violation hearings, which, and I know you've done some training on that, is the whole issue of when someone is removed from transitional housing and we get a code 16 violation
Yep.
versus a code 7, which is the programming.
Yeah,
If it's a 16 and they haven't left of their own accord and they still consider that their residence, it's a challenge for us to find that that's a violation, whereas it's pretty clear if they're removed from that program that it's a condition 7 violation.
Or,
Yeah.
or if a complete eviction has happened. There's been some times where an individual may be told that day that they need to vacate the premises, and that's when it's coming as a 16,
But they still
but
inform,
they haven't had a chance to,
Yeah.
they still inform the PO,
right?
so they really, so 16 doesn't really apply.
to the lack of residence.
So they.
Change without
Change
getting
residence,
permission.
because they tell the PO, by the way, I've been
Yeah.
kicked out, so they kicked out, so the resident has changed, but it's really not.
And that's something we also see amongst, like, we had that Boswick ruling
Mhm.
around, you know, the residence condition anyways, about whether or not someone can be violated without having a residence and having the opportunity. We go back and forth with the courts a lot around the
Really?
probation
Yeah.
orders and with community furlough supervision. What should, and I hope would happen, again, it comes into education and messaging, is that they're adding that condition 7. I just
There you
looked
go.
at another
Yeah.
case and was like,
There you go.
"Hey, so we like just lost that one
Yeah.
because you didn't add 7." So the messaging around that, but 2 is if they can't propose, they may be terminated from transitional5housing, that they have the opportunity to propose another residence if we do have that condition. And we should, again,
Yeah.
it's still open to human error that they don't, is explore another residence, and that would be a more solid violation would be what I'd hope would happen, but of course, doesn't always happen, as you
Yeah.
guys have seen.
Yeah.
So, I'll lean into that. And I
Yeah.
want to talk to, transitional housing, and I know they have a grantee meeting coming up. Actually, in what week are we in a couple weeks with all the grantees. I would love to see, I'm not sure if the board is receiving any termination letters of the transitional housing.
Sometimes they're included in the violation.
Yeah, and so I'd like that to be stronger across the board as we lean into more of like, as a department, we're looking at these a little more critical of if an individual has been terminated from their own origin of county, if, and how we review transfers, that if their own origin county has exhausted all services, their eligibility in transferring and accessing services in another county, and those kind of discretions around how we're viewing those, to ensure that services are not just get out of jail services
Yeah.
when we put so much into these transitional housing, because we have some really good programs.
Yeah.
I thought, of course,
Some of the POs have brought in some of the program directors from the housing too.
Oh,
as
really?
witnesses, yeah.
The other topic was around resident searches. And I did share with the board the policy. Thank you, Cassidy, for sending that to me. Because it came up where a PO wanted a special condition to say that they could search the residence. So that came up to whether or not we should be looking at, do the POs need the special condition in order to search or not? So that was the main question, because we hadn't seen that in a long, long time.
Yes, that's.
Yeah.
Obviously, I'm gonna support it, but I mean, again, discretion of the board. I just have to, I'm gonna pull up the policy right now. I did
I
send
thought they
it.
had the discretion to do it anyway, don't they?
They have to have the individual sign off on a search form in which
Yeah.
they can decline when we, supervise to different statuses like furlough and they decline allow a search, that residence can be denied. Based on safety and security around
Right.
public safety. If it's a probated order, it becomes a violation of probation. And because the court does allow us to have warrantless searches for specifics around drug, alcohol, and any other contraband, especially with sex offenders. So of course, I think one of your special conditions for the sex offenders has a warrantless search. So whether or not the board chooses to apply that to drugs and alcohol, which would mirror the probation conditions, I mean, that would be something to discuss with your legal.
So the standard condition, which allows them to visit them at their home or place of employment whenever as necessary, would not extend to the policy that DOC has for searches if it's warranted.
I wouldn't think that it would, I wouldn't think that that would extend, because it's allowing to visit the home, but I don't think it's
Yeah.
explicit saying that they could search the home.
Again, the individual would have to consent to it. It's very
Mhm.
specific around, you know,
Yeah,
and we'd have to have that reasonable suspicion.
right.
There's
Your
plain, like,
policy is pretty
I-
clear.
Yeah, that I can't just walk in and say, hey, I don't
Right.
like you today. We'd never do that. But like, you know, if there was evidence of drug paraphernalia, like
Needle
a
on
crack
thing.
pipe or something like that, and I'd be
Yeah.
like, here's my,
Yeah.
dude, I have reasonable belief that you're using drugs at this time. I'd like you to consent to a search of contraband. But again, it has to be linked to their risk
Yeah.
associated. You know, I'm not gonna be, and we'd have to be specific, just like we are with the sex offenders. Are we looking for electronics? Are we looking for specific stimulus to their risk with that warrantless search? But even a warrantless search, they still have to sign off.
For transitional housing, aren't they, is that part of the rule, the deal, for most transitional housing, you can search?
Actually, we cannot necessarily search if we don't have the
Okay.
condition. However, the transitional housing has built into their own policies and procedures that they can key in. I think they still have to follow that landlord tenant,
Yeah.
like, hey, we're coming in. If it's a welfare check, I think all bets are off, just like with law enforcement, that they can key in. But it has to be pretty specific of like, hey, we have reasonable belief. We can present that to the grantee, then they can go in. Or I think what has happened more recently, somebody has been terminated, they come into custody, the transitional housing court go in and they find weapons, and that's created some cause of concern and looking more in depth of how we're approaching these. As we know, risk has changed a lot for our communities.
So one of the things that when I was reading through your policy, I thought we could consider doing too is just modify our standard condition and just add a clause, something to the effect that if the DO search policy criteria is met, they must submit to that.
Yeah. Well, DOC would love that, I bet.
Because I don't think we're in a position where we want to object to that at all. So
Yeah.
if that's so.
Yeah.
That would be a standard condition. So the search would only be there if the criteria to conduct the
Yes,
search.
reasonable,
been met.
yeah,
Yeah.
word specific, be able to articulate, and also that there's, I'm looking at some of this stuff right now.
Yeah.
In possession of the.
I will make a note for when we future amend our conditions, because
Okay.
we're not gonna amend currently because of the amount of work that it's gonna take in order to change the system and everything. So I think at this point.
Even if we just wanted to add language to an
we
existing
cannot
one.
add- We cannot add language to an existing one without going through a huge process of modifying.
Condition 18 or something.
Yeah,
If we want to. So if the PO requested it, that would be the way to do it.
that's what I would do it right
Yeah.
now. But because I think we put all condition changes on hold for until at least the beginning of the year, until we can I think.
So Cassie, if you can figure out a way for us to amend that one.
Just had the PO requested.
Yeah, I think again, it goes into education and messaging. We have a meeting scheduled at the end of October with the supervisors in LAOS, and I can start working on it. I mean, we do have some, I know MJ and I both have exciting updates about violations and how they're submitted, so which means some changes in OMS. We'll give you a little, but take away the rest, okay? But yes, do I look in.
Okay.
What else we got?
I didn't really have anything.
You had a specific question about a case that came for an in-person record
Yeah.
review and how the release plan wasn't improved and why the staffing team placed 1 year additional for review. So that's an adaptation to our current policy around release notifications. It requires the committee to place a timeline around the next time we'll review and asking for a demonstrated period of compliance and or commitment to reentry planning. So we're seeing plans and have had amazing feedback from caseworkers saying they wrote up a plan in 5 minutes and said resubmit it. That's not a demonstration and or something that the committee can consider as being a good plan. We're asking them to utilize their skills from programming. And so we have looked at other ones where DOC has the discretion where they are able to articulate specific steps from risk and apply it, and or have used education to go and talk about and identify how they're going to write these things out if they have low literacy. So we are actually seeing small changes where the individual who's incarcerated goes back and actually does some work around it versus a quick 5-minute write-up. I'm not going to use drugs. My little kid's going to drive me around so I can get to all my appointments. That's not passing that straight face test. So in order to also, we're putting that timeline and trying to keep consistency so someone maybe is a little more savvy and has a higher literacy, doesn't get a priority over someone who may struggle and need additional work, that there's a safer time frame into which to review. Also, then we're not seeing the same case every week saying, nope, I did it, this time I'm going to go to AA and that's the only revision. This time I'm going to do 90 and 90. Only revision, like that will exhaust the system and won't be productive for both the individual, the caseworker, the PO, or the committee. So that's the only reason that 1 year timeline is there. If they're to do amazingly better, we support that coming forward.
So I think I struggled with the case where this happened because they had, the way that it was presented from the caseworker and the offender was that they had a residence, they had a solid plan, and then it was denied. And then the caseworker came to us and said he lost his residence because it was denied. So then they came to us and said he has no release plan, but he did. So I think, and I don't know if you can, but
I brought my computer this time so I can look at it.
for me, I guess it might be nice to have a little more information on why they're being denied, because it was presented as it was a solid release plan with a pathways apartment, everything set, is what I took out
Just
of it.
because this is an open forum, this is JD.
Yes.
Mhm.
Okay. I think I pulled the specific language that we used in the case staffing, so let me,
You did. And I think that the language I was using, the case staffing, is what was kind of tripping. I think some
Yeah,
of
so
the
it's substantial
case
effort.
staffing
Yeah.
language is tripping the board up some,
Yeah.
trying to understand what.
So
you're
in
meaning.
some of this language is specifically taken to the community parole eligibility statute. So
Okay.
I'm gonna lean into that a little bit if I'm
Okay.
playing so when we say that they are not to be unreasonable risk to their victims and or the community at large, that comes from the statute around the discretion of the Department of Corrections. What we're saying at that point is that I have the wrong case. Is they need to be able to, and it is a committee, so I don't want to think that Cassie's making these decisions all by herself, is that the committee, and let me look at his plans Did they present the plan that was originally submitted that he?
No,
Okay, so that's another thing, again, training and education is that the board can request, did he submit a written plan? Because they are to us. So that might be in your consideration if you choose to grant parole against DOC's recommendation.
Yeah, the only plan that the board saw was the original prior to the case staffing, if I remember correctly. So then when the individual came before the board, the residence was no longer there, and so forth, so.
So, and some of this speaks to how an individual, so I'm just like, I can tell you right off the bat now. Some of this is like their own behavior and actions of how they're going to be in the community. So when people are, and this is again being very general, so not to disclose, information in an open forum is like, if an individual is like, well, I'm just gonna stay away from my victim. Like, so is the victim just, my response is, so the victim's just gonna find you and like, but you know what I mean? That's not a plan to be successful with somebody who has constant recidivism under the community supervision. That's just not passing that, again, straight face test of like, okay, how is that managing unreasonable risk in the community and the victim at large? Because looking at that, that's one of the questions that was asked is like, how are you going to refrain from acting violently? It's not, and it was like very general information, like I'll just not get in a relationship with someone.
That's kind of working.
So I think this kind
It'll
of
work
leads
until some
to,
girl goes by and
Yeah.
sighs at him.
leads a little bit to something that came up at the facility that was kind of introduced. I'm gonna put it out there. We're not seeing these plans that were submitted or how to, so it's kind of hard to know kind of what's going on behind the scenes. And then we also heard about a risk containment packet that's being created. The director of education, or I don't know what his title was mentioning that he's on the risk containment committee helping do.
Classification?
Christopher.
He's like the principal or something. He was saying he's doing helping.
Cosgrove.
Yeah, he's helping with the risk containment packets.
Okay, now I know.
And so he was,
Yes, I know about.
Yeah. and so he was talking about this packet and we're like,
So that packet is not necessarily a packet that's uploaded into OMS. It's taking the case staffing and getting very specific into details about determining whether an individual is being considered for risk containment needs a forensic evaluation and or do we have forensic evaluations on file. So these are like really nitty gritty. So he was talking about, so we are pulling their totality of program history, dates, compliance, it's this risk containment, if I can just emphasize this, makes me, it's a really big decision to make, even though they're continuing to be eligible for release, that classification we take very serious. So when there's a process we have the original case staffing, then we do another review where it's more in depth, where we can cite, these are the actual sources in making this determination collectively as a unit, the director of classifications on it, I'm on it, facility operations is on it, and in making those determinations before someone's actually designated. So that's what the packet is.
so basically what I'm kind of leaning to a little bit, and this was something that I think got, before your time at Central,
Yeah.
got put out as part of, when we were implementing the structured decision-making framework, we had stakeholder groups. And I know that the folks from NIC met with different folks at DOC central office. So it sounds like during that packet is a lot of the information that the board should be getting too, in a way, like with programming. We don't know what the programming history is. We don't know what some of that, we're getting the high level. So it seems like we're getting a lot of scrutiny by DOC on our decisions, but we're only going on the surface level information. We're not always getting a lot of that. What programming have they been done? What are they doing to mitigate their risk? It's an information sharing thing.
Yeah.
And I don't know how to fix it, but I just thought I'd put that out there.
Yeah, I think we want to bring it back to our council of what information. Also a public hearing.
Right,
That
absolutely.
my concern is the information we're looking at is also covered by HIPAA, especially around forensic evaluations
no,
and or
absolutely.
psychosexuals, which aren't even introduced in the, like, when you're at court, they don't
Yeah.
get into those kind of specifics. So I would want to gauge, I can definitely put in that request, but the case staffings, I think, have more information, but what the committee is looking at is specific behaviors that meet the criteria. Like, we literally, like, does this meet this? Does this meet this? And some of the information is in those packets. We'd have to, in order to produce it for the board, we'd have to do a lot of editing. People, you know what I mean? Like, because it's an internal document used to, for decision making that's not, like, just like an affidavit doesn't have, unfortunately, like, you'd like everybody to only use victim initials, but sometimes it is, you know what I mean?
Right.
Like, the same with
Right.
the PSI, like, you do high
How do you
editing.
get it?
How do I get the information?
Yeah, if this
For
is-
document-
Well, if you're starting to talk into the HIPAA world, documents which aren't public records.
Well, court documents are, but psychosexuals are not.
But if they're entered into court, they become a public record.
No.
They're attached unless they're sealed by the judge. But anyway, all I'm saying is, when this forensic evaluation takes place.
Yes,
I'm assuming guy is signing a waiver to corrections.
correct.
So wouldn't it be just as simple to put a caveat in there and to the parole board, if you become eligible, some magic language? So that release is already there?
I'd be happy to propose that, but
Yeah,
that's a
well,
way
I'm
of,
just saying.
yeah, that's way above my head and I don't even think that would be pertinent. Like, to me, I'm afraid they'd also maybe get lost in the weeds. Possibly, like, like, I don't even know what I'm reading half the time without the direction of people like in risk programming who read these all the time. Like, and if already, I'm just throwing out with the caution of playing the devil's advocate. If you're already getting mixed messages from POs and CSSs about when to grant somebody parole around IPOTS, I can only imagine what's gonna happen with psychosexual. Okay, or like even on an interrupt, we were apparently missing the beat there. I would just be concerned about
Yeah.
how that material is presented to the board.
And I'm just throwing it out there.
No, it's
I'm
good
making a
discussion.
note about information sharing. I think that's more of a larger conversation
Yeah,
to have. But it just seems like there's more, and it goes back to a model, it goes back to different models and so forth that I'm who's producing these packets? Is the caseworker or the PO the ones necessarily producing the packets, or should we look at a hearing officer model that we have a staff member that goes in and produces the packet for the
Yeah.
board to review, so forth, that works with everybody?
yeah.
So just stuff that I'm kicking around in my head of other models from other states and so forth.
Yeah.
So I'm just thinking about that information sharing, because a caseworker in a PO isn't gonna know the information. We're not trained in the information, but also that information is very valuable at a high level in decision making.
Well, but what's really only given out is the criteria in which they were designated. So the decisions of the risk containment is very specific to the policy and how it's written. So like, it's like, do they meet these levels?
I'm not necessarily looking at risk containment in
Yeah.
this conversation. I'm looking at general, because it
Sure.
could be somebody who's not risk contained, like what kind of programming have they had? And
And I'm sorry that you're not getting that information now.
we get it sometimes, but sometimes it's hard, as you know, and I'll put it out there, it's hard to get programming information sometimes because the systems are different and they don't talk. And I got the history there too, I understand. So it's just, it's hard because just the specializations and having everybody talk and
Yep, I think,
in all, it's just, I'm cognizant of everything and all the pieces.
sure.
I get it.
I think also, just to put the board at ease, we are looking at continuing, I know the OMS unit is working diligently on the exchange of information and how we're capturing. That's something that we hope to roll out within the next, I'm gonna say 6 months, is how we're capturing risk referrals and programming referrals, as well as terminations and or decisions not to offer someone in a better location within OMS. That is, I can promise you right now, we're developing that now. In the last couple of months, it's just rolling it out. And so then we can speak to how that information is extracted into your parole packet, which is also, you'll hear those exciting, again, not to defer, but maybe to, it updates that Mary Jane and I are working on. Oh, yeah, so Well, I just wanted to see if I've got, there was another presentation pertaining to a in-person record review where there was advocacy to the 4-year interruption and the board being requested to say DOC should apply for ICOTS.
2
That-
years in.
2 years in, it will be addressed within the facility. It was forwarded. That mixed messaging, once again, is about education and ensuring that we're all on the same page. Harder to
Yeah.
do with 6
Yeah.
facilities and 11 offices, but I think we're getting there.
Yeah, yeah.
I'm optimistic.
It's understandable.
I try.
Yeah.
We try.
Angela, did you have something you wanted to say?
No. Can you hear me?
Yes.
No, I'm
Yep.
good, thank you.
Okay, you made a noise, so I wasn't sure.
Okay, OMS, yesterday we looked at, what's so silly is the language and how things are being entered into OMS. We're hopefully going to be and have, I looked at it yesterday, that it'll be simplified for POs to enter and we will cease to having so much confusion around violations, we hope. So that will be rolled out as well, hopefully in the next couple.
So the violation reports have been more automated, so there's been like duplication of conditions, it's just
Yeah.
been more missing. It's just, I think it'll have a little bit more of an impact on office staff than before, because we try to rectify some of it
Before we see it, yeah.
One of the changes to the actual parole summary is that right now, the auto population just has the date of the case staffing. We're gonna ask that it pulls and populates the decision of the case staffing, so that it's not necessarily new information, but it's specific to the decision made from the most recent case staffing, so that you'll have who is on the committee who reviewed it and the decision made and the next steps in that case. So you'll see right there, it'll be noted if it was, positive recommendation, provisional release review, any of that stuff should be in that. I'm hoping, they said they could do it for me,
Yeah.
but they won't auto-populate or pull in all the categories because you should already have that prior supervision, history, treatment, all that stuff, but it will pull specifically the decision over for you.
Whenever we see the date, we always look for the case staffing report.
Yeah, so that's what I mean. So it's like,
Yeah.
why not give you the decision at the same
Yeah.
time? They said they could do it. So that was the last suggestion that we had yesterday in the conversation around the continued development and rolling that out. Whew.
Super.
A lot. I have one question.
Yes, sir.
Tom, I'm gonna call you sir. That's fine. With the case, I know when somebody's violated the parole, it's considered a major violation when it goes referred to a staffing.
Yep, a significant.
Yeah, so, and I might, in the back of my mind, I'm always wondering, a caveat, is it always gonna be, no matter what, a certain amount of time because it's a violation? Or, I know it goes to case staffing, but because it's a significant violation, say, okay, fine, you violated, the minimum's gonna be 90 days. I've heard in the background things like, well, because he had this past history, he's gonna get 6 months minimum.
So there's a couple things I can walk you through it.
Okay.
So if we've definitely cleared up messaging that if they're returned and you issue a reprimand, it's not counted as a significant violation.
Okay, yeah.
They actually have to be revoked.
Yep.
So if you have revoked probation, it will be considered a significant violation. Depending on their score or assessment will dictate, that's like the first step. So first significant, what's their assessment, which if we're using a PIT, which is a PIT ORAS, which
Yeah,
is
right.
done within 3 to 5 days of someone being returned on a violation, that score, low, moderate, or high, will kind of sets the next stage. So if someone comes in on a first significant high ORAS, it's a 1-year interrupt.
Okay,
But then after that, we take into consideration the aggravating and mitigating factors. So aggravating, here's a perfect example. We just did one yesterday, is an individual was terminated from transitional housing. Okay. Has chose to revoke, has ongoing use of substance use disorder. It is very obvious, it's littered throughout their history. We may make note that it is apparent through charges, behavior, that they struggle with substance use disorder. So that's a mitigating factor. However, the aggravating factor is that they led the cops on a chase, eluding an officer with a firearm. There's your aggravating factors. So that kind of like almost washes it out. We may say 1 year interrupt, or we apply the aggravating factors, which is 1 through 7. It's outlined in the, I think you guys have that one. Where is that found? Furlough violations. Is that where it is? Maybe? Anyone? Okay. And there's different criteria that we have to cite is the aggravating factor, because this can all be reviewed by the court. So we have to be specific that based on the behavior of having a weapon or use of a weapon or failure to mitigate sexual risk activity, that's a big one.
Yeah.
If they're unable to mitigate or their risk. And there's a few others, use of weapon, significant harm or damage to the victim records. So you see that around the TVs, new charges or not. Those are the aggravating. Mitigating behavior could be substance use disorder, that they have access or have a plan in place that we take into consider, like they went to their PO, blah, 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 blah. And so we try to make note of that, which then can deter the length of an interrupt.
So to make it easy for me to understand, because I'm a special person, that, so somebody gets gets their parole violated, and that's a substantial issue.
Yep.
And they score high on ORAS. Minimum is going to be looking at a year.
Yep.
And if they have anything else, it could be enhanced by what you just mentioned to whatever the committee wishes to do. But it will be a minimum of a year if they score high.
Yeah.
Okay.
So there's actually, I built myself a cheat sheet. I'm not even gonna lie. I literally printed out and cut and paste, like where's my base and where's my mitigating and aggravating factors next to it that we take into consideration. One, because we have to be able to support any argument in court.
Yep.
So I actually make myself a cheat sheet. And that can be found. Let me double check. I can send it to you again. Case stuff. I look at it every week just to ensure that I'm aligning practice. Because what we found, and Jean can probably speak to it, used to be all over the place.
Yeah.
It's like they didn't have like a set time frame, but it's really rooted in their, I think, the very high ORAS. And then, so here's the other factor. If they're on community supervision, right, furlough, and they got returned, we take also into consideration, do they have a year of success in the community? If they don't, so say they got returned,
Okay,
and then was released to parole, so that you had one significant release to parole, you guys violated him, he actually was only in the community 4 months, that could mean it could be a second, which increases that time without aggravating or mitigating behaviors.
I got it.
Yeah.
The enhancement part, but just so people are aware when they do violate what the
Oh, yeah.
for the former parolee, yes.
Yeah,
Okay.
it's
Interesting.
often captured under custody and placement. In the case staffings, if you are looking at someone who may not be RSN or risk contained, that last case staffing decision should tell you we literally put in the furlough violations, aggravating and mitigating factors were reviewed and did not deter from the length of it. The interruption. I know I write them, so I can verbatim say it.
No, I understand. Okay.
Okay. That's a good question.
Just wondering out loud, MJ, if thinking about that, if when we're doing a violation hearing, if we have access to our SDMF coding form that we used at the time parole was granted, and we have some aggravating issues that were noted in there, and then this behavior that we're addressing now relates to that, it help us with our decision making.
Yeah, I think it's something that we should look at working on, because I know we were gonna work on updating our matrix and tying it more into those aggravating, mitigating factors. So I think getting moving on that. I think that would help and help point. Then it's more clear of how the board's
Yeah.
gonna make their decisions. And will help you all kind of.
Yeah, when you're looking at the offender history and you have a chance to just quickly look at the STM form.
Because those forms are right in the files
Right.
and you have access to the files.
So I'm sending Mary Jean the response to furlough violation. I just pulled it up and it's specific, and I'll put the page numbers in. Literally, again, it's a cheat sheet.
I understand. I figured there'd be a cheat sheet with it anyway.
Yeah,
I
like-
was just wondering, did I hear that in the
No, that's
background?
great. Yeah.
Yep, and I find that helpful, and then it goes down to speaking about the mitigating and the aggravating. I can list like engaging in multiple crimes impacting public safety,
Mhm.
use of a weapon, injury that resulted in medical services, behavior with a victim or survivor who's considered a vulnerable person, has severe or prolonged negative impact on the victim or survivor or the general public safety or health. So like a potential impact to large number of victims, which you may see for someone who's, I think we just looked at, just hypothetically, like that an individual was detained after a full standoff with law enforcement. That impacts.
That would be bad.
Yeah, like it was a full standoff. So like that is a little bit of an aggravating.
Yeah, I
factor.
that I can understand.
Yeah. And then mitigating factors that's present include, and they list there, where it is motivated by substance use. There was no impact on public safety. So say if they're like using at home and no one's
Yeah.
hurt, that may be something to consider. The individual has diminished cognitive capacities, that there's something more going on. It's somebody who's maybe demonstrating an increase of need for mental health services that may be considered at the time of the violation. And there's evidence that the individual was under duress, coercion, threat, or compulsion, which may be
Yeah.
found in an affidavit or whatever the case. So we try to take this in consideration for every significant violation.
In a parole, to reiterate, a parole violation is significant.
Parole revocation.
Revocation, I'm sorry, revocation is,
Yeah.
I remember wrong.
Yeah,
Is
parole revocation.
is significant.
The
Yeah.
conclusion.
Yeah. Okay.
What else you got, MJ?
What else do you all have for?
Any other?
You're making any more confusion out there? Just kidding. Better education and communication out there.
That'd be all the policies for the last 5 years.
Yeah, I got that.
Yeah.
Right under they're all giving me a hard time before you guys got here about like, Cassie, you're just gonna update another policy? Like, trying.
Question,
Yes, sir.
do they get good time? I'll serve in and interrupt.
Yes.
Earn time.
Earn time credit
Yep,
unless they're on parole.
that's right.
Just want to make that clear.
On parole, they do not.
If they're on parole and holding on a graduated sanction that you may have imposed, they do not earn time during that time. They have to be in a incarcerated to serve
Okay.
status.
Yeah, I think there's specific reasons why they can't earn time while they're incarcerated. To interrupt DRs.
DRs, yeah, like, so they have to be, and it's only major DRs, they have to be convicted of a major DR in that 30 days, then they only lose that specific month. And I'm the worst, so I would defer if you want more to bring.
No, I.
Sentence comp, because
Oh, God, no.
Yeah, like,
That is counts, no.
we could bring in sentence comp to explain it more. I try to stay away from DOC math as much as possible. And I've worked here a while, so I don't like to answer those. I always defer to sentence comp. But yes, they are eligible, depending on the charge, of course.
So it's the same as state employee sick time.
Yes. Oh,
Exactly.
oh my gosh.
You use sick time and you use sick time when you're out sick.
Yeah, kind of.
It's a beautiful thing.
When you say it just like that, that's
But you
Kind of
get extra
entertaining.
but depending on your contract, you might get extra personal leave if you don't use.
That's
your-
right.
yeah. So does it?
Yes. You're
Like,
10
you
hours
think
before.
5 days in a row, but I only get
No.
But they don't want you being sick
Yeah.
anymore.
But I guess it might be have ability to some balance the
Yeah,
two.
I know, I used to get the 10 hours every.
Um,
Let you some of it, and I'm looking at it. I'm a grown woman, I'm using. How does this
how does this
work?
work? I'm very, I rarely. I've been in nonprofits and I'm like,
I get back over something.
hours.
Holidays,
That's crazy. Yeah, it's amazing. I don't complain about it. As a state worker, I'm very blessed.
Trust me.
Anything else
From me.
as we digress?
Anything else for Cassidy?
But I do know that, I really appreciated the questions and like that Mary Jane
Yeah,
has gone
I
and
tried.
she shot the questions. And so I was able to like have those and be prepared. So I'm
Yeah.
very willing to do that.
Thank
You know,
you.
if you find it monthly or bi-monthly or however.
It's very helpful.
Yeah, it is.
Appreciate
Yeah.
it.
I'm sorry I blindsided you then.
For what?
I'm sorry I blindsided you.
Oh, and
then.
the furlough, oh gosh, no, I'll talk furlough violations all day. It's, I think I live and breathe case staffings right now. So,
I'm sorry.
gosh, no,
I think
yeah.
I need to make notes as issues are coming up.
Yeah.
Parents or questions are coming up. So I'm trying to keep a running little notebook.
Well, and it's confusing. I think the staff have gone through a lot of transitions and it's just about education, excuse me, education and communication, which we've done, just for little stuff to update you. We have done and are doing more in-person staff meetings with the supervisors and the LUSs and that messaging. We're rolling out a lot of different services, which you might see pop up come January 1st around VCCI and bringing more people in. So that's exciting. But yeah, we just are constantly working through it.
Thank you very much.
No, thank you. Appreciate it. We'll see you guys after lunch. I'm gonna stay. in
You cleared everything up, thank you.
Yeah. Enjoy the rest of your meeting.
Thanks.
Thank you.
What's next on the agenda?
Just a heads up, doing I wanted to propose to all of you or show you what. We're on the preliminary violation hearing,
Oh,
probable cause bail.
Yeah.
I'd like to change the form to be more compliant with our manual. Kind of like what I was talking about last month about kind of getting away from the word bail. I
yeah,
know, Dean, you have, and I was gonna update the script a little bit. Just because our manual talks about preliminary violation hearings. It does not say anything. We do not call this a probable cause or a bail hearing in our manual at all. We don't talk about bail, I don't believe. We talk about custody status and release. So I want to try to get away from that. So I wanted to update the form to be more cognizant of that. So let me zoom in a little bit, kind of show you what I wanted to propose. It's not really changing the data or what we're doing. It's more just changing the title to preliminary violation hearing. Changing that we had probable cause hearing and we also, and I don't know why we had the word hearing after, and we had bail hearing here. And I think this is more of just checking off, are we dealing with probable cause and are we dealing with custody status? Really to get away from the term bail because they don't have a right to bail, but we can release them pending their parole violation hearing. So I want to just kind of, because we're not actually asking them for any money or anything like that. So just trying to shore up some of our paper. And I know, Dean, in your hearings, you've been sticking away, you've been not bringing up bail. Is this a bail hearing? You're more on the custody.
I just don't like
status.
using that because we're not ever going to ask for bail.
Right.
Yeah.
So just kind of like I've changed it to the pertinent information, probable cause, same thing. And I just changed the bottom to just say custody status.
Yeah.
And then I changed this section to say conditions of release imposed until the parole violation hearing. And it was something like bail conditions or something to that effect. So just some wording.
Mhm.
And Becky, you can correct me any way you want. But it's just more of just trying to shore up some of that language, because I really like to get away from using the word bail if we
Yeah.
can, because it always brings up that PRO argument of, this is what the bail statute says. You can only use risk of flight
Right.
as a reason. And that also brings me back to, I really want to take some time to work on the violation section of the manual to really start outlining, make it clear in our policies and procedures, what our reasons, what you're looking at in making these determinations. So it's more clear than anything, to try to combat some of this. I talked
Great.
about it a little bit last month, but I just
Yeah.
wanted to follow up with kind of the way.
I mean,
was-
if you have, if you have a document, a Word document with this, the original of this. I'd
Yes,
love
I
to-
do. I will update that too.
Okay.
That'll be next on my thing to kind of update the
If
script.
you just want to send it to me in a Word document, I can update my own. Okay.
I think that would be helpful because I'm just starting to go through some of this. For a while, I took everything for granted. Like, you guys have been doing this for years. I'm like, oh, well, let's use let's use our terminologies that are in our policies,
Yeah.
not have terminologies.
Sounds good.
I just wanted to show it to all of you. We'll kick this out with October,
Sounds good.
or any forms that haven't already been created. So Colby, if you've already created a bail form, that's or a preliminary violation hearing. I know Colby's already told me this is a tongue twister for her. Because I did warn her the day that I covered for her, I started using all of these terms, and Dean went right off behind me.
Anything new on the violation matrix? Have you?
I need to get working on it. Hopefully I'll have something for October. I'm really looking forward to coming next week. I like having these 2 weeks when we don't really have any hearings. Hearings take up almost a whole day of my time.
Good. And what's next?
Structured decision-making framework. Discrepancies, hold on just a second, I actually worked on it on the way down here. So I can pull up individual cases, I haven't. I will say, from the looks of things, a lot more forms got kicked back last month than I've seen in a while. There was more yellow about areas that weren't filled out, and just seeing that people there was just a little bit more kicked back to all of you for not completing your forms, so just.
I had
be
one
cognizant.
because I forgot that
The new
bottom part,
reason.
the reason part.
Yeah.
Yes, so I have now instructed Colby and Carla, if you are not putting in a reason. for
Oh, they're
your
sending them back. That's great.
decision, I have
Yeah.
told them to send it back to you because it's really
That's good.
important that you are putting a reason why you decided to deny your grant.
Might be thinking that's something, I did not get any kickback, so thank you. There, I mean, you think that's something else from that, I did not
I read
get
it
that.
awful.
I did.
Like this.
I didn't even see that little bottom section addition, so I got 1 day kickback because I forgot we were putting those in.
So
and
there
I
were a
missed
few
it.
cases this month, where there were discrepancies. I think it's a mixture of I don't know if it's all of you, but I think it's a mixture. So I don't think I'm gonna pick on anyone like I did last month. But Tommy did show up a couple.
I know, I got nothing kicked back to me, though. I'll take that as a win. I'll take that one as a win.
So I don't know if you wanna look at a couple cases, if you want me to pull ones where there was multiple, like we had, but I think Michael Alger, Angela, I'm gonna look at those forms. I'll look at yours because I think that one might just be a training thing. I don't think we need to do that one as a whole group.
Okay.
'Cause I know you've asked me to look at your forms and I have not. So I don't know, Dean, how do you want to do this?
Just want to pick one and go through it?
Okay. Pretty graphic. Let me stop sharing at the moment.
I know.
Wow, you guys usually are like to each other. And this is like silent.
Justice. And the state trooper for that does all the forensics and stuff. Oh, their body cams.
Yeah.
It will do, AI does their
Report.
report for them. I absolutely amazing, everything. I said, I was just listening to him talk that your body cam does your report. Think about that when you were, how much time it would save. But all responsible to the state trooper is to review the document.
And agree with it. Yeah.
So Jordy Levick was seen, he was recommended at St. Albans, PMP this month.
St. Albans?
I don't know.
He
Where did it
had,
go?
Oh, she's bad.
so he had an institutional and community behavior. It was Pat, Tom, and Angela. I have Pat with a mitigating and Tom with an aggravating.
Obviously,
Angela came in as a neutral. So let me see if I can pull up your notes. There. Route.
Every was on what section?
Programming.
Programming. Ah, okay. I'll defend the programming one.
So Pat had done, but tips are incarcerated and SOT in the community mitigating. Did complete the tips in facility and in community, but poor history of supervision, but been doing better since December. Neutral. I
Mine
think our
was,
spreadsheet's wrong. I have you listed as an aggravating. Our spreadsheet's wrong
aha. See, all these ones I've been dinged on, it probably was.
because Angela was a mitigating too. So either I messed up the spreadsheet this morning or the other spreadsheet. I'll make a note to.
I feel vindicated now.
Well, good job.
Yeah, see, yeah. I would go back the last 8 or 9 meetings and go back and double check.
Okay, review all those, MJ, will you?
Yeah.
Well, we reviewed them during the hearing.
Yeah.
So it should be mitigating, neutral, mitigating.
See,
Tom
So,
demands a
okay,
recount.
You don't need to review that one.
see, now I had got none kicked back, but I was right there, saying, okay, I feel much better.
You can just blame me, Tom. It's my fault. It's always my fault.
I always refer to you when I, there was a mistake, so I absolutely.
Here's another one. This is actually the case that we talked about with Cassidy. Let me pull up Jeffrey Davis. Give me one.
Jeffrey Davis.
Yep. It's Pat, Sam, and Wayne.
What day was that?
Newport. So last week.
It's always bad.
Last week, it should be fresh in your mind. And we just kind of talked about the case a little bit.
The in-person record review.
The forms are not in the folder yet. Bear with me. Let me go get them. Need it on the spreadsheet. Oh, you got them on the spreadsheet.
I'm working on that data entry now because I am behind.
All good. I just gotta go get I just gotta go get it. Good. You combine the SDMF forms because Pat's folder's missing.
Yes, I combined them.
Okay. Are they in the done folder? Are they in the
Yep.
hearing? Where are they?
Hearing forms.
Thank you. Yes, Leah's sick, though, that's why she's.
There's definitely something going around.
All right, so we are looking at programming again. I have Pat at the neutral, Wayne at a mitigating, and Sam at an aggravating.
Sounds right. I'm either neutral or aggravating. Nobody hit the golden cross this month.
The golden buzzer.
Oh,
Nobody got there.
Okay, so Pat wrote neutral, has completed RIS 9 months while incarcerated, has also been on MAT. He will need to participate and complete a domestic abuse program in the community.
Like a good neutral.
yeah.
I would have probably done neutral on that one too.
Neutral to me.
Wayne has completed required 9 months RIS to include DV, voc rehab, MAT. Will need IDAP community based.
Do they even do IDAP community based anymore?
And you gave him mitigating. Because he did twice.
Well, mitigating work.
I mitigated them for the same reason you're neutral.
That's right.
Like,
Sam,
Ah,
He did all he could.
aggravating, has completed RRP in the community and RIS in the facility and has had other programming options, and CSC is not aware of any more programming that would be available to address the risk areas. What does aggravating say? I'm curious. Based on the other two, I don't know how I get aggravating.
Yeah.
Anybody got it open?
Should've gone neutral.
I'm
I
mitigating.
think he did all he could.
Yeah.
He did all he could that was available.
Corrections.
We didn't finish it, or he was,
Right.
The aggravating?
Yes. The aggravating says the individual has not completed correctional programs based on risk. And additionally, it says the individual was not afforded the opportunity to complete such programming or were assigned to such programming and failed to participate and complete, but not at a degree high enough to have affected a reduction in risk. Mitigating is the individual participated actively and completed the required assignments based on their risk, needs, and responsivity.
Mitigating stretch.
Yeah, because he,
Neutral is the individual has completed some programs, one or more, dealing with one or more elements of their risk, needs, and responsivity, but not adequately addressed. Neutral is pretty good on that one. Yeah.
Articulate how to mitigate his risk.
All right, Wayne, we're both wrong.
No, I'm changing, I'll tell you why, but at any rate,
I'm not
It's
asking
mitigating.
anybody to change.
he's done everything he possibly can do, and correction said, we're not doing anything more for you. So how more mitigating can that be? And the guy is willing to do
and he
something,
completed
we're
it,
told,
successfully
we
completed
got
it.
nothing for you.
what was the reason they took away IDAP?
Can't find providers.
Really?
My mom used to teach it
Like sex offender programming, so they can't find providers.
for the Bennington.
Any
Yeah,
others,
she used to
MJ?
teach it.
Nope, that's it.
I feel vindicated.
Anybody have anything with, anything they want to talk about with SDMF?
Yeah, the thing about using them at violations, I think would be really helpful.
I think maybe referring back, but I wouldn't use it to base your decision.
Yeah.
It'd be nice to see, we go back and see but yeah, I agree, that'd be.
You should be using your structured decision-making framework in your parole decisions.
Okay.
Whether you're denying or granting,
Right.
you should be taking into account those domains. And then you should be able to link your decision based on these risk-related domains.
Absolutely. What's next?
Roundtable.
Round table. Pat? Anything?
Rectangle.
Rectangle to me.
I'm good.
Sorry, rectangle table. I think everybody should come up with something, positive or negative. You should say something every month, because this is where I struggle with the staff meeting agenda every week.
Yeah.
Every month is, I come in and blurt out to all of you and nobody has anything. So why are we meeting? So let's go around and just say something positive. So if you don't have anything, you gotta have something going on. Whether it's good, bad, indifferent, there's something.
I like who I have in my hearings every month.
There you go. There you go.
I don't know that I've got,
It's not a time for, it's not, roundtable isn't necessarily meant to be issues. It's meant to encourage conversation.
Thought it was a great positive thing to bring everybody to Rutland and have a tour of a facility where people have no idea what corrections really is until it's.
Yeah, can we do that for all the jails?
Not in the winter. Newport is a.
Well, that's true. That's true. Not
I
the winter.
want to tell you how far from Islamont to Bennington that ride is.
I don't think it would
Seven
be,
from one end to the other.
I don't think it would be necessary to go to all of them. But maybe a potential, maybe we can look at every quarter or something, maybe I might be able to look at maybe more like a Southern or a Newport, the bigger facilities, because if you went to Marble Valley, you go to St. J, they're the exact same.
Yeah. You know what? I
Maybe
kind
to
of,
the women's prison, something like that.
I was gonna-
Women's prison would be eye-opening.
yeah, I was gonna say, I'd like to, I mean, because this was my first experience seeing them, but
It's a.
I think I would be interested to see the difference in a women's prison, but I would also like be interested in seeing how they run like the work camp one
St. J.
and at St. J, and how they do, if there's what's different about that one, and
The work camp basically.
because like how does that program
it used to
even
be a
different? Like how does that
program where
work?
they let people go out. In fact, that's on some of it. We had guys working in Open State. Basically, they don't do that much anymore. They cut a lot of wood. They run the boilers.
They are going out.
Yeah, they're still going out. They go
There's-
they go to Montpelier,
And
and
kill school teachers.
but it's not what it was designed for originally, which is unfortunate.
Yeah, so currently, I
Yeah.
think the big thing with work camp right now is work camp was designed for your non-listed, your low-level offenders, your low-risk offenders. And right now, the population is taking a severe turn.
Mm.
There's been a lot of decarceration initiatives where the people with those type of crimes are not getting incarcerated. So the work camp they've always had trouble filling it.
Really?
Oh, yeah.
And
Okay.
because of those, you can't be a violent offender. There's
Those sex
specific
offenders.
criteria to why you cannot go there. And it's a 50 person bunk area where they all are in bunks. It's open floor plan. And then they do work or they go out on cruise.
So let's say someone back in their early 20s commits a pretty egregious thing and they are an incredibly long sentence.
Mhm.
As they age and show positive behaviors, they can't work their way into there because of their original crimes. So like someone that committed it at 23, at age 50, they couldn't work their way into.
How it used to work in corrections, you incarcerated, you went to St. Albans, closed custody. You work your way through the system and eventually you would end up at Windsor. And that would be like a max out program for staff and everybody. So you could be like a murderer or whatever, but you work your way through the system and you end up to Windsor. Then they changed it all into this new thing with the work camp, and the criteria was pretty.
You also got to think that work camp. So the other thing with work camp is you earn day for day time. So you can get up to 30 days off of your sentence at the work camp. There are other.
For DUIs.
There are other opportunities in the other facilities. If you say medically you couldn't go to the work camp, you could work in another facility and still get that same time. They have that for the women as well. But yeah, it's not, it's been phased out a lot, and a lot of it's due to these decarceration
The other thing is,
initiatives.
judges aren't stupid. So we call corrections math, you've heard the comment. So if you know that Wayne, a DUI 5, he's gonna do, we want him to do 2 years in the work camp, because he's gonna get qualified for it, the judge will give him 4 years. With that, knowing that he'll get out in 2. So
Okay.
judges aren't stupid, they understand. So this whole conception, they get day for day, they do, but the judges also know.
They start with more.
Well, the thing is, so when Wayne gets in trouble at the work camp, gets kicked out, now he owes 4 years, not the 2 years, which was the intent.
And I don't know where, so also I don't know where things are at with like, you know, they were phasing out of like Vermont Correctional Industries and so forth with like, I don't know where they're at with all of that, but that might be a better thing to see of like the vocational stuff than I think, than the work camp at this point, where they're learning some of those vocational skills, because they had a print shop, they used to have a furniture shop. I don't know what they have
I think they
anymore.
closed everything, but they're supposed to be doing something. I wrote a grad paper on that, but I said, isn't it nice to know that we send people to vocational skills when they get out of jail, they can make license plates. A lot of openings for that in the real world. I wrote a very good paper on that, I remember, about the inadequacies of vocational training.
Right.
Thank you.
Are the sex offenders distributed now and still St. Albans, or did they move that?
Well,
unit to
they have a
Springfield?
program. I don't know what the program is
I
now.
know there's some, I know
Like
there's
St.
some
Albans.
programs, some- I think St. Albans has become more of a detainee
Yeah,
facility.
yes.
They send a lot of their sentenced out.
Is that what's
Because a lot of them go to Newport.
back in my?
We follow to Newport a lot of the time for St. Albans.
Great, thank you. Anything else, Tom?
No, it was just that I brought that up because about the violation. So now when you violate somebody, it's going to be an impact. So that's something to be aware. There are going to be most guys or girls are not low.
Thanks. Sam?
I think last week I struggled with the Newport Day. Cause I think we had one case, the first one where the caseworker and the PO were advocating for very different things. And then we had the other case that we just talked about. So I think,
Ashley talks about
yep.
it.
And then last month, I think we talked about another Newport case. So I think I don't struggle with the Newport days, but sometimes I'm like, I just don't understand what's happening up there. But yeah, but it's nothing that we can do. It's nothing that's done wrong. It just sometimes I just don't get it.
There's a lot of staff turnover, a lot of people retired, new people. I don't know what Newport is, but I do know other places. I mean, a lot of people are leaving. A
Mhm.
lot of new staff are moving in, so it's gonna be.
But that's all.
Thanks. Well, it's really important to have deliberative sessions too,
Mhm, mhm.
especially if you're not sure what direction you're going with, or if you got questions about something like that, brainstorm it with the other 2 people on the board and do that privately and then resolve it and then come back with your decision. Years ago, we didn't used to do that. And this is very helpful, I think. Yeah. Thank you, Tom, again for putting this together today.
Oh, no, it was not, again, it was nice to see some people.
Yeah.
It's always nice to go back, and what I did notice is not throw with them the security process, because as somebody who ran the place, and it was nice to see the place was clean. And one thing, if you go to the facilities, you notice how quiet it was in that building.
Yeah,
That means you have control.
yes.
And it was clean. So yeah, it was nice seeing people, and it was,
Yeah.
that was nice. Still need my hour of PTSD to.
Yeah.
We can schedule that right after this.
But what's interesting is the people I talked to over the year, many of them were there when I started 30 years ago,
Wow.
and they're still there. And some of them, I know you guys have seen them.
Yeah.
You have seen them on the parole board yet, so I don't know what the answer is, but it's,
Yeah.
no, it's,
Yeah.
it's
Interesting.
kind of looks at you like, but again, when people ask me about successes, you don't see the successes. All you see is the failures. So the people I saw are failures. But we've had successes, but you don't, you always, like when I was teaching the public school, you always remember the negative parts, and the kids get more negative reinforcement than positive. It's easier. So here in and when you're incarcerated, yeah, we have plenty of successes. I know, I've run into plenty, but the only ones that come, that you remember are the ones I just saw. I knew their names, I knew they've been in jail forever.
Well, I too think what's important for us is the early discharges. Those are our successes in many cases. Yeah. We get to see them one last time and send them on their way
And then hope to never see him again.
and then hope we never see them again. Katie?
I think one of the things that I've been thinking a lot about with hearing over the last few months about turnover with DOC and kind of the switch in priorities is where is the thinking and the planning for what's lying ahead with programming? I would love to hear more about, is there any thought on that? Is something being directed towards trying to revamp as they're getting new supervisors in, new directors in? Is there going to be, is that also, as much as they are looking at risk containment things, are they also looking at programming things? And that's something that's just kind of really important to me, because I keep hearing, we don't have this, we don't have this, we don't. And I even see it in the town I live in, you know, because with my job, I am now having much more of an interaction with probation and parole and their frustration level with it too. And my hope is that as we're getting new directors in and new people at the top, that's going to be looked at just as much as the risk designations and that sort of thing.
Like Marble Valley has no substance abuse. If anything, we have NA, AA maybe. But I always,
Jesse did say they're using turning points in there more.
turning points are allowed. We got that in right for them, but that's having a real program.
Yeah.
Because the overcrowding programming goes out the window a lot of times.
I just feel like if the more, and I know it's more of like, this has to be cut because we need to look more at risk, but my kind of thinking is the more programming and the more things you put in place, it's going to hopefully pay off down the road with less, recidivism. My
I
hope.
think-
Is a big,
I do have a plan to bring in the programming folks. I just they haven't got them on our list, on
Right.
the list. But it may not be until after the first of the year, but I do plan on bringing them into a staff meeting to kind of go over what's available, what's not available, that kind of stuff. Kind of go over the whole, because I know they've gone through a transformation in how they do not just programming. It's now risk intervention services, which encompasses education, programming, vocational. It encompasses all of it now, and they're not separate entities. So I will see about getting them in.
The other thing, Katie, to be aware of, this is my correction this year's, when you require programming, your head count is through the roof. And you require people to do more programming, that means they're staying in jail longer. So what do you think is gonna happen?
Well, and DOC, it doesn't have to be just within the confines of the facilities. I'm thinking like, within
In the community.
within DOC themselves, within probation and parole. Like, what are we looking at with that? What are we
Well,
going
I
to be
think
putting in
probation and
place?
parole so programming has ceased in probation and parole. DOC is not responsible for it. They are partnering with the communities now in the community programs. There is no longer any risk intervention services programs in the community. They are partnering with local entities.
And the problem with that is a lot of the designated agencies are overwhelmed and they can't offer those anymore. So how are we doing that?
What they did was, why provide educational services on the street when by law, anybody over the age of 6 is entitled to a free and appropriate education? They said, go to school. So now you have a guy that's 45 years old, can't read or write. He's not gonna go to school. But those are the things that they look at. Duplicating services, I believe they call it.
Good question.
That, and I mean, I would also love to see more mental health stuff in the jails too, but that's just me.
The
But I do,
board is not gonna solve that problem.
no, I know,
That is
it's
really
just,
impervious.
it's just disheartening to, especially when you're in the parole hearings and you hear about so many things that have affected them from early on, the substance use and,
And I think you have to be
trauma and.
I think you have to be careful with some of that too, and being a clinician, you have to be careful what you're hearing, because sometimes they may not be telling you the full story.
Oh, yeah, for
And
sure.
they're telling you
What
what
they
you
want.
what they think you want to hear.
Yes.
Kind of like
And
the,
they're not
Skim milk.
blame everything. So you gotta lay it out.
kind of like that case we were on, was it last week? With like the restitution through the
Okay.
roof and they hunt over 180 victims.
Oh, yeah.
Oh, my goodness.
Angela,
No, I'm just kind of still, I don't know, sometimes it's a little tough when I'm prepping for the hearings and looking over the SDM form and looking at all the stuff. Sometimes it gets a little bit confusing as to what the what the correct response should be. But I think it's just still just kind of me just getting used to the procedure, I suppose. I mean, we had that one hearing that past week where, the person that we had the hearing with definitely should not have been released on parole, but they were getting released soon anyway, so the better option was for them to get on parole. So things like that can be a little discouraging, but it is the system, and yeah, I guess I'm still figuring it out, but I'm getting there.
yeah,
One thing also, Angela, kind of to talk to you, to get a little bit on the coding and so forth, is also if you're in deliberatives, don't be afraid to ask the two board members you're with, what are you thinking on this?
Yeah.
How are you coding this? I would love in deliberatives to hear more of you guys going through your forms, and you can shake your head all day, Wayne.
Well, Neil, all right, you just hit my nail on the head.
Well, this is what this is part of your responsibility as being a board member.
Okay, well, when we all bought into this SDMF, all I kept hearing is, this is not a score sheet. This doesn't make your decision. It helps you make your decision. But when we go into the deliberative session, MJ, let me finish. We consist.
Wayne, I'm not gonna have this conversation
Please.
with you. You just went over the line. I am stepping out. I am sorry.
Okay, well. then-
I didn't say a word, didn't even say I was gonna say a word.
So
I'm
this
not
is what
gonna go
this
down
is
this
about.
road with you,
All
Wayne.
we hear in deliberative session lately is when there's an issue is, what is your SDMF form telling you? What is it saying? And that, to me, interprets, it's a score sheet, because if I got aggravating, there's no decision to be made. I'm sorry.
yeah.
That's where it's at.
But that's coding.
It's coding and scoring,
Well,
because we've paroled a lot of people that have aggravating. So if I'm trying to figure out how to be consistent here and saying, when I hear, what's your score sheet? What's your form telling you?
Yeah.
My form's telling me is, why are we wasting our time?
but when you say there's aggravating, a lot of times we have aggravating on the first two categories because that's a
Mhm.
historical,
It's pretty consistent,
but it's a historical thing. And so that doesn't reflect on what's happening at this hearing at this time. So as you go down through there and you look at programming, we've had a lot of discussions about that. Sometimes programming is being offered, sometimes it's not. If it's not, how are we categorizing that? A lot of times,
Neutral.
the majority of them are in substance use issues and they're in treatment for that. And that's a good place to reflect what's happening in there as well. But if they're doing things in there, that's not going to be aggravating. The ones, and so as you look through that and as you go through the interview and you finish up I do mine ahead of time I handwrite it. I have it in front of me as I'm going through my interview, and then I complete it after the hearing when they go on the the document page and fill it out. And then some of those I may change because things come up in the interview that either one of you said or asked, or things that were asked by the PO or some comments made by the offender, and it changes my mind on how I'm reflecting that. So in the end, I'm going back and looking at that, and then I'm not calling it scoring. I'm looking at the various categories that reflect where they were, where they are now, what they've done to get there, and what we expect them to do, and what's their release plan, and that kind of thing. So it's not a numbers thing as much as it is each one of these domains is important in its own right, but it doesn't reflect, if I have 3 aggravatings, I'm not going to parole them. It's just, where are those aggravatings and what's happened since then? So in the end, I can make a decision with the other 2 board members that hopefully is consistent. And I can write a brief comment after that that reflects why we made, or in this case, I made that decision to support granting or denying parole at that time.
Get it? I understand. But I don't understand how you can comport one to the other. That's my problem. Especially if you have people that are, the majority of those are aggravating. How do we parole them? And we do it all the time, and I don't have a problem.
I don't think I've ever
because
paroled
what I'm
somebody who
hearing-
has a majority
Well,
of
we could
aggravating.
probably have somebody with magic computer pull them up and look at.
Yeah,
I think you're gonna see that we parole a lot of people that are more aggravating than anything else.
I'd be surprised.
Okay. I don't know how to do that,
Are
but
they recommended? You
there could be there for a minimum or, yeah, I don't.
Does anyone
I don't
else
worry
sense
about
that?
them. I gave up looking at
No.
recommended a long time ago.
No.
They're here for a hearing.
I mean, I pretty much always assume that for the majority, the first couple of categories are gonna be
Oh, yeah.
aggravating.
Unless they've got a limited-
Unless it's a very limit, like first couple of,
Yeah.
And most of them have a DR within the last, what,
2
year?
years.
Yeah.
So that's usually aggravating, because we don't see
Yeah.
very many people who do not have a recent DR. So a lot of times that one's aggravating. I find that programming is usually neutral for me because they've done some incarcerated, but they
Yeah.
still have some to do.
Well, and programming is where,
In the community.
Yeah.
programming is where I get super frustrated because,
You know, there's.
like I said, there's nothing for, like,
They can't do any. They
Right.
may want to do it, they can't. do it.
like I could see a ton of things that could benefit them, but
Yeah.
there's just not offered.
When
I
you
give
get
them a
you get
neutral-
into their
They're not
category
there.
on with some offender, you're looking at going, they're not gonna program
But
this.
we've all
because
agreed
he
that's
doesn't-
not aggravating.
No.
Yeah, right.
That's,
So it just,
Mine is
like when I see it, and then the other one is it's really hard to look at change
offender change.
It's always a
because
tough one.
they,
I rely on the questions that they answer
Until they
a
have an
lot.
opportunity
Yeah.
to demonstrate.
I usually have to score that neutral
this domain
because,
doesn't reflect on what they actually have done. It's, are they indicating to you in their discussion that they are changing or have changed? It doesn't have to be proof that they have.
yeah,
And I rely a lot on the questions
Yeah.
that they've had to
Mhm.
answer. on
Yeah.
the form.
me too.
Yeah, those are very helpful.
They are to me.
Okay, staffing.
I know, I don't like it when I get one and they haven't filled it out.
I know.
I'm like, oh.
So you don't like the Chittenden Day? Cause they all bring it to us and read it.
It just, yeah, I guess. I don't know which one does it the most, but I get frustrated when they don't fill one out. Cause it's like, how can you really have any insight into?
Yeah.
It just helps. It's so helpful when they do.
It would be, I've asked a few times if they've had the opportunity, a few times I've heard. So it would be kind of nice to have check mark that they had the opportunity, but chose not to. Just a thought.
Anything else on SDMF? Okay. Next up on our agenda,
Executive session.
we have a motion, or do we have a motion
I'll make a
to
motion that we go into executive session to discuss
legal matters?
No, personnel.
personnel matters. Okay.
Second,
Motion's made and seconded, and we would include our staff and our attorney. All those in favor signify by saying,
Aye.
okay.
Just got a message that my kid's going to urgent care.
Oh, no.
I guess his tonsils are like huge. We're gonna go, since we're supposed to
You need
leave.
to go.
No, he's 18. His girlfriend's taking him. She's in control. I mean nothing anymore.
I hear you.
It's all her. I'm gone by the,
Right.
I'm gone by
I'll look on the screen. All right, we are now back.
Okay, so we're out of executive session, no action taken. I sent out the schedule yesterday. I don't know if everybody had.
Oh, I didn't get it.
I didn't get it.
Send it on the email.
Yeah.
You want me to, yeah.
Yeah.
I can post it.
No, yeah, I don't check the state one, but I'm glad it's out there. Thank you, because it's really helpful to get it out.
Yeah. Had some challenges this month coming up because there's a lot of time off for folks, which is okay. Figure it out.
Whoever the day before this, I'm busy.
I think I'm on that day.
I'm busy. There you go. Oh, one reason.
You are, you're on TP, you're on the, are you on the long day?
Anything? Yep.
I didn't put November schedule on because I didn't know when you were sending October out, so, the one thing about November, I'm gonna ask that we not have a board meeting that day and just leave the Tuesday before Thanksgiving as a potential overflow day.
Okay.
Because our normal staff meeting would be on Thanksgiving.
And then what's starting in December, would then that move to virtual?
Because we moved next month's staff meeting to Tuesday, the 28th, I believe it is.
Yeah.
And overflow is on Thursday.
Good. I think that's all we got.
Motion to adjourn.
So
Second.
motion's made and seconded to adjourn. All in favor?
Aye.
Place across the street is
Excellent.
very good. A great chef's salad. Well, and you also have Gills down the way. That's also very good.
Good, you gotta drive that.
It's like a mile.
So we could get something and come back here
Yeah.
or
Are we coming back here?
Yeah, go on.
no, I was just gonna eat my lunch here.
Okay.
No, the chef's salads are very good. I get quite
It's
ready.
on the recording.
Let's see, a little few people and I'm gonna.
Anybody else gonna have their lunch back here or
No, I have to go home and get ready for a school board meeting later.
you gotta go to urgent care?
She's got it covered. Let
Okay.
me tell you, this girl,
All right.
she, no, whenever.
State company, you made, to say you wanted.
All right, have a good day, Angela.